Welcome everybody. Thanks for joining us today. I understand that a lot of you will be dialing in from home given all of what is going on with coronavirus, and hopefully our system and your systems work. But we do have somebody online, so if you've got any questions, you can send through a help question to them. So let's get started, because today I'm going to be covering quite a bit of content in relation to trademark ownership and control. So we will be going through a few cases. So if I can go through a few cases with you. The first one, well, there's a few cases, 5 that I'll be covering today, and then at the end of the presentation, I'll do a bit of a summary as to some key observations and some key takeaways. So because the content's a bit heavy, we'll move fairly quickly. So the first one I want to look at is around, sorry, if I can just pause for a minute and say that we're looking at these cases because there's been a fair few, you can see the dates there, in 2018 and 19 that have come through in relation to the validity of registered trademarks being challenged. And it's either because it's in the incorrect company name or because the use hasn't been considered valid because it hasn't been under the control of the owner. And that can have quite significant consequences. It could mean the removal of your trademark from the register, or it could mean that you may not be able to enforce your rights. So that's why we're having a closer look at what's required. And one of the key sections that it's important to understand for these cases that we're going to discuss today is Section 8 of the Trademarks Act. And that section is where we hear this phrase, under the control of the owner. So a person is only an authorised user if they are using the trademark under the control of the owner, and the use that they might have evidence of is only going to be valid evidence of use if it is under the control of the owner. So if we have a look at the first case, this is going back a little bit, so I'm hoping that some of you are already familiar with the facts. And the case is Lodestar and Campermurray, and originally the name was Skyy Spirits, but they changed their name partway through, so hopefully that doesn't confuse everybody. So in this case, there were a number of parties. There was the wild turkey interests and the Irish whiskey interests, who were having a bit of an ongoing dispute. And there was Mr. O'Sullivan, who was he was a barrister, and he's down in South Australia, and he had a winery. And there was a wild geese trademark registered to Irish whiskey, and unbeknownst to Mr. O'Sullivan, he didn't know that existed, but he filed his marks as well for wild geese and wild geese wines. He received an adverse report, and he then thought that he might seek to remove the trademark registered by Irish whiskey. And when he was investigating that, he realised that there was an ongoing dispute between wild turkey and Irish whiskey, which he didn't really want to be a part of. So he noticed that because wild turkey was in a non-use dispute with Irish whiskey already. So what he decided to do was assign his, he got in touch with Wild Turkey, and he decided to assign his trademark application to Wild Turkey in exchange for a license back. And that way he was planning on going on with his winery down in South Australia and exiting the dispute. So he received a license back. It wasn't a very comprehensive license, but he got on with selling wine. My slides are a little bit out there. They say he was selling whiskey, but what he got on with doing was selling wine. And ultimately, Wild Turkey took over the non-use proceedings. So the non-use was effective, and Irish whiskey had its mark for wild geese removed. The mark that Mr. O'Sullivan had originally filed and had then assigned to Wild Turkey, sorry, the application that was filed and then assigned to Wild Turkey was then registered. And Irish whiskey, because the dispute was continuing in other areas, they waited the requisite 3 years for a non-use removal. it might have been 5 years in this case, because it was back in the day where you had to wait 5 once the mark was filed. And then Irish Whiskey sought to remove the mark that had been filed by Mr. O'Sullivan. So Mr. O'Sullivan's busy selling his or using his mark for wild geese in South Australia. Irish Whiskey has filed non-use proceedings against the application held by Wild Turkey, and the court had to consider, was Mr. O'Sullivan using the wild geese mark on his wines under the control of the Wild Turkey Interests Company. So they're very confusing facts. I hope you were able to follow them or you've read the case before. So Wild Turkey argued that they had a license agreement in place with Mr. O'Sullivan, and it was a pretty skinny license agreement. It had some provisions about Mr. O'Sullivan not using the mark outside Australia, and it had some requirements that he could not amend or abbreviate the marks. And it said that if they requested, he would need to provide a sample of wines to them, and some analysis would be undertaken to make sure that they were of export quality. So they never requested any wine samples from Mr. O'Sullivan. Basically, the agreement was drawn up and he put it in his drawer and they put it in their drawer, and they just, each party got on with their business. So they tried to argue that the license agreement should be enough and that they had the ability, if they needed to stop Mr. O'Sullivan using the mark if he stepped outside the terms of the license agreement. So in theory, they were saying they had control. And Justice Pham was of the view that they did not have any actual control. He looked at the evidence and he said, well, I've got the document, but other than the document, there's no evidence of actual control. There's a question about what the requirements of the Act were. And Justice Pham said, there was a previous case called Yow's Entertainment, and in that case, Justice Pham's interpretation of it was that it might have meant that theoretical control, having an agreement between the parties, was enough. So he thought he was bound by that full court decision in Yow's Entertainment, and so he then made a finding in this case with Lodestar saying that theoretical control might be enough, in the sense that if Mr. O'Sullivan steps outside of that license agreement, then the license agreement was enough to prevent using the trademarks. Now, the issue with that is that Justice Pham had the interpretation of Yow's Entertainment incorrect, but we'll discuss that in a second. And his interpretation was not quite right, because in Yow's Entertainment, it's an old case, but it involved videos being made, and the person making the videos had to actually ensure that the video being copied was of high standard. So in that case, the quality control checks and balances were considered to be actual control. So on appeal, the full court said what Justice Pham was saying about theoretical control was wrong, and they said that in Yow's Entertainment there was actual control, and what is required in this case concerning the Wild Geese Wines trademark is actual control from time to time over the mark. So there must be control as a matter of substance, and it's not enough to have a license agreement with some standard provisions that is put into a drawer and nobody pays any attention to. So that was the 2016 case, and that sort of set the benchmark for what is required. Then there was a little bit of a gap while everybody absorbed that information, and then there was a flurry of cases over the last 18 months as to the application of that finding in a range of circumstances. So I've got 3 that I'll go through. One is the case of Calico Global and Calico. And it's going to get really confusing because a lot of these cases, there's a fight over the same trademark. And so the names are actually very similar. So this one here, it's a trademark for Calico and applied for in relation to class 41, which is your entertainment and education services as well. It covered information in relation to fitness. So class 44 is your medical services. So Calico LLC is an American company, and they were trying to get themselves registered in relation to Calico, Class 44 for medical services. There was the existing registration owned by Calico Global. I'm going to call them Global just so that we don't get confused. And it was in relation to, it was on the register in relation to this Class 41 and 44. So at the Trademarks Office level, the delegate of the registrar decided to remove the Calico Global trademark because the delegate was of the view, at least in relation to Class 44, the delegate was of the view that there was no use in relation to the medical services. There was some limited use in relation to fitness, and so Class 41 remained, but the American company really just needed to get Class 44 out of the road. Now, the reason why we're looking at this case today is because of the structure, and it's really important to understand the different structures with companies and how it can affect the authorised use requirements for trademarks. So this particular matter involved Kevin Owens, and he applied for the Calico trademark in 2004. So that's fairly standard. He was operating as a sole trader at the time. Later in 2006, he set up the company Calico Pty Ltd, and that company he owned half of it, 50% of it, with his wife, and he was joint director with his wife, but he was the managing director. So everything's still fairly ordinary at the moment. That company, Pty Ltd, was then using the Calico trademark. So the trademark was later, so Calico Pty Ltd then set up another company, a subsidiary company, which was Calico Global Pty Ltd. That was in May 2011. And that company started using the mark then. You can see from the slide that it's got a number of shareholders within coming on board, and there was Kevin Owens, who remained the managing director, but also other directors involved. Now, at that time, the trademark was assigned from Kevin Owens to Calico Pty Ltd, and then Calico Pty Ltd put in place an exclusive license to Calico Global. The register, though, wasn't updated. So on the trademarks register, it still had the trademark in the name of Kevin Owens, even though the beneficial owner was Calico Pty Ltd, and Calico Pty Ltd had been acting as an owner by putting in place an exclusive license agreement. So it's a little bit tricky then. So I've drawn this timeline up so that people can understand the non-use period, because as everybody knows, if you file a non-use application, the non-use period runs for 3 years, ending 1 month prior to the non-use application. So when you overlay that on the timeline with what Kevin Owens was doing, he had the mark in his name and he was using it himself. And then there's a small period of time at the start of the non-use period, relevant non-use period for this matter, where he was using it and it was in his name and everything was okay. Then there's a big chunk of time during the non-use period where the mark has actually been assigned to Calico Pty Ltd, but it's still been left in his name on the register. And the register was not updated until after the non-use proceedings had been filed. The issue was whether Kevin Owens, who's the party on the register, had actual control over Calico Pty Ltd's use. And then a second issue was whether Global was using it under the control of Calico Pty Ltd. And there wasn't any evidence of actual control in this situation. And you might recall at the start I mentioned in relation to the Class 44 services, medical services, there wasn't any evidence of use. This guy, Kevin Owens, was basically a fitness instructor. So he was doing things in Class 41, and Calico, the American company, is in relation to medical devices and vaccines and things like that. So when he saw them getting bigger and bigger and might have wanted to use the mark, he then started to try and put on his website some medical services or things that looked like medical services, but he did not have actual use in Class 44. So what he was arguing, though, leaving aside the fact that he didn't have use, was that he was arguing that as a managing director of Calico, P2A Ltd, so if I go back a slide so you can see the structure, he was arguing that as a managing director of Calico P2A Ltd, he was able to exert control over Global, and that way he had control over Global's use of the mark. And the problem, though, was that it was still in the name of Kevin Owens. So the court rejected the argument, and they said that Calico P2A Ltd is a distinct legal personality from that of its officers, including Kevin Owens, and by assigning the mark, the Calico mark, to Calico P2A Ltd, Mr. Owens was in fact precluded from using the mark himself. So that he actually had given his rights away. The rights holder was Calico P2A Ltd. So Kevin Owens himself could not have been the party exercising any control. And the fact then, if you have a look at, okay, was Calico P2A Ltd controlling use by Global, the fact that he was a managing director was not enough. So that ownership structure did not of itself show control. They said the differences, the court said, Justice Raries said that the differences in the shareholdings in Global and Calico demonstrated that Calico Global was not under the control of P2A Ltd, which was not under the control of Kevin Owens. So a little bit messy for Calico Global, Kevin Owens, and Calico P2A Ltd. So, as I mentioned earlier, the fact that there had been an assignment in between actually precluded Kevin Owens, who was the party on the register, from being able to say that he had any control whatsoever. And it was Calico, when you looked at the evidence, it was Calico P2A Ltd that was exercising the rights of an owner when it entered into the license agreement with Global. It actually said that in the document. So all of those things meant that the person on the register could not have possibly been controlling the mark. Now, in this case, does that mean that if you fail to update the register, are all things lost? I would think possibly not, because in this case, there's the extra question about should the court exercise discretion. Now, if you had done everything right and there was control and there was use, but you'd failed to update the register, then that might be a situation where you can say to the court that discretion should be exercised because there's just been a procedural, an administrative failure to update the register. But in this case, there was no use of the Class 44 medical services. So the mark, there was no reason to exercise the discretion and the mark was removed. So let's have a look at the second example of Hells Angels Motorcycle Corporation and Redbubble. And I'm looking at it again because it's a different structure and it's important when you've got a corporate group and trying to organise licensing and within the corporate group, or perhaps you've got a corporate group and you need to license out to licensees or franchisees. This different structures are important to understand. So this particular case is quite a long one by Justice Greenwood. The majority of the case deals with copyright infringement, but I'm not going to talk about that today. I'm just going to focus on trademark infringement. And it was a trademark infringement claim by Hells Angels Australia against Redbubble. And Redbubble cross-claimed in the proceedings to try and remove the Hells Angels trademarks and try to get out of infringement that way. For those of you who aren't familiar with Redbubble, it's a global online marketplace for print-on-demand products. And what I mean by that is that they have a platform where you can upload images and you can have that image reproduced on t-shirts, cups, mugs, whatever it is that you're seeking, whatever merchandise that it is that you're wanting to produce, and they'll do it for you. So Redbubble got themselves into trouble in this case and another one, predominantly to do with copyright infringement, because people were obviously downloading images off the internet and uploading them onto Redbubble and manufacturing, arranging for the manufacture of heaps of merchandise. So that was primarily the heart of the case, but trademark infringement was an element that Hells Angels had pursued, so Justice Greenwood had a look at that. And so background in relation to Hells Angels Motorcycle Club and what Justice Greenwood called them, he said they were a group of motorcycle enthusiasts riding around on their Harley-Davidson motorcycles. And the history with that club is that it's set up in San Francisco, and what they had originally was charters. So that was back in 1948, and there were quite a lot in California. And then eventually it got more and more popular, and they created the Hells Angels Motorcycle Corporation in the US, and they had their famous death head logo. And as well, the corporation or the charters expanded into Australia. So in Australia, there was also different clubs, if I can call them up, that they set up in Australia, and then eventually changed into corporate entities. So on the slide that I've got up now, that's just showing you the trademarks that are registered in Australia by the US entity. So there's three device marks and 2 word marks, and those have been registered. You can see the dates there for quite some time. Now, an important point in this case is that the proceedings were instituted by the Australian entity, Hells Angels Australia, not the US entity. So that has some implications, which we'll discuss shortly. I'll just put some pictures up, because pictures always break things up rather than lots of words. So these are the images that were being uploaded onto the Redbubble platform, and Justice Greenwood was of the view that 3 out of the 4 constituted trademark infringement. He formed the view that the one in the top right corner with the Hells Angels motorbikey and the little girl sitting down was not trademark use per se, and so given it didn't constitute trademark use, it couldn't be a trademark infringement. But the other 3, he said, were trademark infringement, so he had to then go on to consider the various issues in relation to the trademarks infringement claims. So like I mentioned earlier, the proceedings were instituted by the Australian entity, and there's 2 issues that caused. One was that entity, if it's an authorised user, has the right under the Trademarks Act to institute proceedings. Now, if you've got a trademark licence and you've prepared it up and you've given third party right to use the trademark, that third party, if they're an authorised user, will have the right, pursuant to the Act, to bring proceedings without your permission, unless you've taken that right away. Now, in this situation, Hells Angels Australia had the right, it wasn't taken away from it, and in fact they had instituted proceedings in the past. So they claimed to be an authorised user, and Redbubble was trying to dispute that they were an authorised user to try and prevent the proceedings continuing by the Hells Angels Australian Corporation. So the second question, if Justice Greenwood did find that they were an authorised user and had standing, the second question then followed on was whether the use by the Australian entity in Australia was under the control of the American entity, and to show that they were an authorised user, because if they were not, then their use did not count for the non-use proceedings, and perhaps then there would be no use in Australia. And if that was the case, then the non-use proceedings, the cross-claim for the non-use proceedings would be successful, the mark would be removed, and that would then mean that Redbubble might be able to get out of an infringement claim. So Justice Greenwood had to go through and have a close look at what was going on between Hells Angels in the US and Hells Angels in Australia. Now, there was a lot of evidence, some given by some bikies who were about 80 years old. It was quite an entertaining read. And they said, which is not surprising, that they didn't have any written manuals or guidelines. What they did was normally oral, and this is in relation to the use of the trademark. But they were pretty organised, and they had a license agreement between the two entities. So the license agreement was in 1987 originally, and then it was updated in 2010. And in that license agreement, it gave exclusive license or right for the Australian entity to use the Death Head logo and the Hells Angels trademarks, and the use of the trademarks had to be consistent with the standards that they said from time to time. Now, the evidence was that any restrictions and standards was oral. There were no sort of emails going back and forwards between these motorcycle enthusiasts. What they did was oral, but nevertheless, there was a license agreement. And as well, Clause 8 said that the Australian entity had to report to the US entity about the use. Now, Justice Greenwood applied the Lodestar decision, which said that having a license agreement is not enough. You have to actually be looking for whether there's actual control or a connection between the use of the trademark and the registered owner. Now, the evidence showed that there had been control over use of the patch, the Death Head logo on the patch, and there was quite rigorous control around where it had to be placed and the layout of it, and there had to be standardised stitches. There was also evidence around the creation of a new Death Head logo in electronic format, because the one from the 1950s was, they found that there wasn't consistency in the stitching, and as technology improved, they needed to have an electronic patch or image that could be applied to the patch to clothing. So there was actually evidence of that control, even though nothing was in writing. There was also in Australia, the gentleman who was responsible for merchandising, he had a little bit of trademark experience, fortunately, and he knew that the license required reporting back. So there was evidence in 2011 and 2014 where he had unilaterally reported back to the US entity about the merchandise and activities that they had been doing in Australia. And in 2011 in particular, he was reporting back in relation to proceedings. So all of that was really good evidence of the parties working together. And even though there was a license agreement, there was additional evidence of controls around the quality and presentation of the patch. So Justice Greenwood said there's no doubt that the US entity imposes very particular controls around this patch. And if you take into account the nature of the organisations, and you've got this agreement in the background as well, he made a finding that there was common ground, or it was not necessary for the US entity to be giving directions and instructions all of the time because of the closeness with which they were operating and the nature of the entities. So things that he took into account, he said they were brothers in arms, they were primarily domestic club entities. He said they were behaving and understanding their respective roles. So the Hells Angels Australian entity was behaving as an authorised user and reporting to the US entity. And all of those things taken into account, he said, he said, I don't see any reason to depart from what seems to be a relationship where there is obedience to the trademark owner. And he said that was so intuitive and so complete that no formal instruction was necessary. So when I looked at those words, I thought, oh, is that wording just because we're dealing with a bunch of motorcycle enthusiasts? Or is there something more to those words? Now, I had seen them somewhere before, and they were used in the Lodestar case, the first case that we talked about. And in that case, in Lodestar, the court there was talking about control being a question of fact and degree, and that you need to look at the evidence. And sometimes you'll have a complete lack of control where the licensor has given rights to the trademark and then just doesn't do anything else. And there's other cases where the licensor has, is constantly monitoring use of the mark. There may be very rigorous license agreements in place with brand guidelines. So there's this varying degree. And so the words Justice Greenwood has picked up on there are not just because he was inspired about the relationship between a bunch of motorcycle enthusiasts. He was actually picking up on something in Lodestar, and it's something to consider each time. So I'll go through the third case now and just give you a look over that one. And like I mentioned earlier, I'll do a recap at the end about some of these key points. So this case, next case that we want to have a look at is Trident Seafoods Corporation and Trident Foods. So again, very difficult with the wording because I'm going to say the word Trident about 40 times. So bear with me while I work through it. So we're dealing with some Trident trademarks that were on the register in the name of Trident Foods. So the 3 trademarks that you can see at the top, 2 of them were in relation to class 29, which is fish and fish products. The third one that they own was in relation to class 31 grains. Then Trident Seafoods came along and they wanted to register Trident Seafoods. It received a citation and was not able to proceed because of the pre-existing marks for Trident. And Trident Seafoods then applied, filed for non-use proceedings at the trademarks office level to try and remove the Trident marks owned by Trident Foods. There we go. See, I said Trident at least 8 times. So that was at the trademarks office level, and the delegate decided that there was no use in relation to that class 31 grains trademark, and that mark was removed. So it didn't, there was no dispute, there was no use, that mark got removed, it wasn't part of the appeal. The delegate at the trademarks office decided that there was some use in relation to fish and fish products, but determined that it was not under control. So the delegate had actually thought that that they'd exercised the discretion. So it went on appeal, and if we have a look at the structure, because it went on appeal in relation to use and also in relation to control. If we have a look at the structure of this one, this is quite fairly standard when you look at it at first blush, in that you've got one company and another company's wholly 100% owned. But in this case, it was a little bit different because Trident Food had owned the mark Trident, and it was selling products under the name of Trident. But then in 2000, Madison Foods acquired Trident Food, and when they acquired it, they acquired the mark. And what happened was Trident Food stopped selling the product and Madison Food started selling the product. So that caused a situation where Trident Food was the owner and Madison was using the mark, but Trident Food was a subsidiary of Madison. So the question was whether the subsidiary could control the parent's use of the Trident mark and whether that would then constitute authorised use. And as you can see there, there's common directors in this particular scenario. Now, these companies they were part of a bigger corporate group, and Bright Food Global Distribution Company owned them both, but I've left that off because it just is not really relevant to the immediate structure. In this case, there was a license agreement, but don't be fooled by that. It was signed about 2 days before the trial, and it was a classic case of lawyers doing some fancy drafting. And the recital said that there had been an unwritten license agreement in place since 2000, and that Madison was the authorised user of the trademarks, so sort of some unilateral assertions to try and make it look good. But at the end of the day, the authorities have shown us, and we've talked about at least 2 this morning, where the license agreement itself is not enough. So it really came down to what was the evidence that was given by the directors, and Ms. Swanson gave some evidence that she thought she could ensure control because she was a director of both of the companies, and she saw that she had a fiduciary obligation to act in the interests of Trident Food, and she, because of her position as director on both companies, could see whether or not Madison Foods was selling the goods of a high standard, and if there was any concern about the use of the mark or the goods not being of appropriate standard, then she would have intervened. And she also gave evidence to say that at the AGM, the directors would meet and have a look at what was going on in relation to the use of the Trident marks and what products were being sold, and they would sign off at the end of the year. So Justice Gleeson, at first instance, had a look at that and said that She didn't think the corporate relationship between Trident Foods and Menison was enough. That relationship was not enough of its own. And then when she looked at the evidence by Ms. Swanson, her concern was that it was in the nature of the assertion. It was sort of about what she would do if something was wrong, not about what she was doing in terms of monitoring and keeping track of the mark. So Justice Gleeson said that there was not authorised use, but she did recognise that within this corporate group there was use of the trademark by Menison, and she exercised her discretion to keep those marks on the register. So then there was a further appeal to the full court because the Trident Seafoods Corporation was obviously not happy that the mark stayed on the register, and Trident Foods was still not happy that there was this suggestion that the corporate group and the structure in that form meant that there could not be control. So if you are familiar with the Trademarks Act, you'll be aware that there is a deemed control provision. So you're deemed to have control if the use is by a subsidiary and the parent owns the mark. So that one, just try not to be confused with this case that I'm telling you about in that provision. So if you have a situation where there's a parent corporation and the mark's owned by the parent and it's used by a subsidiary, then that is deemed control under the Trademarks Act. This case is where the reverse is at play. So the subsidiary is the owner and the parent is using it. Or it might be sometimes in a corporate group, maybe one of the companies in the corporate group is using it, but another company, maybe with different directors, but maybe ultimately owned by a similar entity, is using it. So when you have that situation, this case might be relevant. So on appeal, Trident Foods argued that there was actual control and that Lodestar, the case that I talked about earlier, the first one, had to be followed. And Lodestar in that case talked about control being a question of fact and degree, meaning that there must be some cases where if you've got, there might be cases, of course, where the licensor has no regard absolutely with what the licensee is doing, but there must be other cases where perhaps a licensing agreement is in place with brand guidelines and there's obedience to the trademark owner either because of that, or maybe here they were arguing that the corporate group common directors meant that there must be obedience to the trademark owner. And the full court agreed, and they said where you've got a situation where you've got this corporate structure, it's not about whether the trademark owner, so Trident Foods, was owned by Menison, and that it was not about the fact that because it's a subsidiary, it therefore cannot control. So that's wrong, that conclusion. You can't jump to that conclusion. You have to have a look at whether the subsidiary exercised control over the trademarks by the parent. And in this case, where there was common directors and common ownership, they said that was a situation where they talked about unity of purpose, and that control could be inferred because of the common directors and the common trading activity and common purpose. So they sort of set to one side the parent-subsidiary relationship and said where you have that common purpose within your corporate group, then it will be considered to have control from a trademark perspective. So that is really helpful because there are a lot of corporate groups out there that were getting nervous because they had trademarks sitting in one entity and it was being used by another entity. But if the companies have unity of purpose, then the requirement to actually demonstrate actual control might be then rendered redundant. If you've got common directors, common purpose, then you should have enough to satisfy the authorised use requirement. So in that case, sorry, just to finish it off, Menison's use turned out it was authorised use and they actually had use of the mark. So therefore the mark stayed on the register and Trident Seafoods was not able to secure was not successful with non-use and was not able to secure registration. So I'm going to jump now to, before I do my summary and recap, I'm going to jump to one other case that has come up. It's a 2017 full court decision. And that's because if you can remember back to one of the first slides where I talked about Section 8, I talked about authorised use requiring demonstration of control, but it has to be by the owner. So it's actually a two-part test in that Section 8. So it's control by the owner. In this case, Pham Global is about who is the owner of the mark. Now, at the moment, we've seen decisions where people are attacking trademarks for non-use and control, and we've just seen cases where people are attacking marks and they're invalidating them because they're saying that a party is not the true owner of the mark. And I think it's only a matter of time that we'll see cases involving a combined attack. And I say I think, but actually I argued a case last year. So hopefully we'll see a decision on that if the judge has an opportunity to write it now that we've all got coronavirus. He might have some more judgment writing time. So I think that we'll see cases, depending on the facts, where people will argue a two-pronged approach. So this Pham Global case happened a little while ago, so I'm hoping that some of you are familiar with the facts. And this case involved a clinic in Western Australia called Insight Clinical Imaging. They were using their mark since 2008. On the other side of Australia, in New South Wales, Mr. Pham applied for registration of a trademark for Insight Radiology, very similar. So he was smart. He did apply first, and then subsequently, the company his company Insight Radiology, started using that mark. Now, it was originally called Pham Global, the New South Wales company. It was called Pham Global, and later it changed its name to Insight Radiology closer to the proceedings. So again, I'm going to have to say the word Insight about 15 times, but I'll try to do it slowly so I don't get everybody confused. So Mr. Pham applied for his mark. He kept it in his name. He then had his company, Insight Radiology, operating in New South Wales using it. And then the WA crowd worked out something was going on. They ran off and filed an application for their mark, Insight Clinical Imaging, in October 2012. And then they received a citation, an adverse report, and they sought to oppose Mr. Pham's application. Now, during the course of that opposition proceedings, Mr. Pham quickly assigned his mark to Insight Radiology and changed the company name from Pham Global to Insight Radiology to try and make it look like everything was okay with the application and in order. So that mark was found to be substantially identical by the Trademarks Office and the full court. And the question that was before, so it went on appeal, and I'll just talk from the full court level because I don't have time to go through all of them. So the evidence at the court and the ground of opposition was Section 58, which is that Mr. Pham was not the owner of the mark because somebody had earlier in time used a substantially identical trademark. Now, there was an analysis about whether Mr. Pham was the owner of the trademark or whether his company, Insight Radiology, was the owner of that device. And so when they looked at the evidence of the case, it came out that Mrs. Pham, so Mr. Pham's wife, had actually come up with the idea for the name of the company. But the evidence also showed that the image, the logo, Insight Radiology, was designed by a third party, and that the company, Pham Global or Insight Radiology Pty Ltd, had paid that third party to develop that logo. There was no license agreement in writing between Mr. Pham and Insight Radiology, and Insight Radiology had also secured domain names in its name. So the company had gone and acquired domain names and had been using the mark since March 2012. So Mr. Pham had never himself used the mark, and his evidence was that he didn't intend to authorise the use. So sometimes, and it wasn't said by Mr. Pham in the witness box in this case, but sometimes people have filed marks in the name of perhaps an individual or another entity to try and hide them on the register, particularly for brand launches. And in this particular case, Mr. Pham didn't say that was his purpose, but he did say that he wasn't intending to authorise the use. And when the court had a close look at what was going on, they said, well, Insight Radiology actually owns this mark. It created it. It went to a graphic designer, at least for the device logo, and the copyright for that logo vested in the company. So the word is a little bit different because the word can be created without a use of a graphic designer. But all of these things pointed to the fact that it was Insight Radiology, Pty Ltd, that owned the mark and not Mr. Pham himself. And it was owning the mark and using its own mark, and Mr. Pham was not doing any authorisation of use. So if we have a look at what the ownership requirements are in the Act, the person who can apply for a mark has to be the person when they file an application, it has to be the person claiming to be the owner, and that person must be intending to use it or is using it or intending to authorise the use or is authorising it at the time of filing. Now, the Act doesn't actually say the words at the time of filing. In this case, had quite a bit of discussion about whether it was at the time of the filing or not, because Mr. Pham had assigned the mark out of his name and into the name of Insight Radiology during the opposition process, and was of the view that as long as he fixed it up before it was registered, it didn't matter. And as long as he got it out of his name and into the right entity before registration, then it would all be fine. So there was a discussion about that. And I'll just jump forward. Basically, I'll just give you the answer, but the answer is you can't do that. So the date that's relevant is the date of filing. So if you don't have it right and in the right person's name at the date of filing, then the registration is invalid. It can't be fixed afterwards. So when we look about who is the right person to have it in the name of, there's two bases to be an owner of the mark. We can have common law use, so if we can call it old school use, you created the mark and you're using it, then you've got authorship in the sense of first adoption and use of the mark. The second type is where you have an application to register, and you have authorship in the sense that you have adopted the mark first, and then you file an application with an intention to use it, but you might not have use yet. So that combination is what catches people sometimes, because sometimes the adoption or the authorship might be in another entity or by another person, and it has to be with the party who's applying for the mark at the time of filing. So when the court had a look at the purported assignment from Mr. Pham, they said it was irrelevant because what needs to happen is it's got to be correct at the date of filing. So the subsequent assignment didn't correct it. And even if the assignment was allowed, then they said the assignment would have no effect because they said Mr. Pham's not the owner. He didn't create the mark. Insight Radiology created the device, at least, by engaging that third party. And if the mark was created, it was done probably by directors in their capacity as directors who have fiduciary obligations to their company, and therefore it's within the company and owned by the company. So Mr. Pham assigning the application across to the company would have no effect because he had no rights to assign in the first place. So it wasn't an argument in this about whether Mr. Pham had control over the company, but I think that the case, like I said earlier, can be extrapolated to the situation where it's got to be under the control of the owner. And maybe when they talk about the assignment, they say the assignment would have no effect because Mr. Pham's not the owner. Well, I think that can be extrapolated to authorised use, and that authorised use would have no effect, would not be valid if it's not by the owner. So the court hasn't exactly made that yet, but we'll see what happens with my case and when a decision's handed down. So let's do a sort of recap. And some of the observations about this case in particular, that where you've got these issues of control and by the owner, I think it's important not to conflate the two tests. So one is about who's first adoption and authorship, and the other is about corporate group structuring, unity of purpose and having actual control, or if you don't have unity of purpose, having actual control. So they're two different tests, and I have seen situations where people muddle them together and they argue corporate group structuring arguments in relation to Section 58 opposition arguments, and I think it's important to separate them. And I think, and there's no cases yet, but I think we'll see more cases along this line because people are trying to get out of trademark infringement by arguing these points. I think there's going to be a situation where there might be a valid mark on the register that might be used by an entity within a corporate group, and there is use of the mark, but the owner of the name's incorrect, and maybe it hasn't, sorry, is correct. Sorry, the owner of the name. So if you think of the Calico global example, where maybe the mark has been assigned and there's an incorrect party sitting on the register. It's just an administrative blooper, but there is use and there is a valid owner using the mark. I think that situation you might see in non-use proceedings. The court would exercise discretion to allow the mark to remain on the register, and then it's just a formality of updating the owner on the register. Where there's a situation where the person on the register was the invalid owner and was never meant to be the applicant in the first place, my view is that the court is probably unlikely to exercise the discretion to allow that registration, that invalid registration, to remain on the register. I believe that's one that would actually be removed, even if there was use. So let's recap key takeaways. So I see some questions popping up, so I will try to get to them in a moment. Just got a couple slides to go, 2 slides to go, we're almost there. So key takeaways in relation to control is that it's a question of fact and degree. So theoretical control, having an agreement and just hoping that you could enforce some provisions is not enough. But it is a balance, because you might have an agreement in place where you have brand guidelines and a very close relationship between the parties, and those brand guidelines might stipulate with rigour what is to be done. That closeness, that document though will not of itself be enough. You'll have to still demonstrate evidence about the closeness between the parties and how that they might believe they have an obligation to report back or to use it in accordance with the brand guidelines. You'll still have to show evidence of the closeness of the relationship. The best thing to do though is to, if you're a brand owner, to periodically check in to make sure that your licensee is doing the right thing and following your brand guidelines. And that check-in should be at least once every 3 years. Better to just do an annual reminder. If you're the licensee and your licensor isn't checking in on you, do what they did in Hell's Angels and unilaterally report back to your licensor to say, this is what we're doing, we're complying with the brand guidelines, here's examples of our use, to protect the arrangement that's in place. So common directors and common ownership, where there's 2 companies with unity of purpose, is probably going to be enough. But if you're in a dispute, you'll probably have to show evidence of the unity of purpose argument, activity. So if you've got different directors and different ownership, then you're probably going to have a really difficult situation. If you don't have a license agreement in place, you'll need to show some evidence of actual control. So in relation to ownership, and the second part of the Section 8 test, so ask yourself whether you have had an entity using the mark yet. If you haven't got an entity using the mark yet, then you would be claiming ownership probably on the basis of filing an application, because it's not being used in the market yet. If you have got use in the market, you need to be really careful that the entity that's using it is the applicant for registration, or those rights need to be assigned out of the entity using it and into the name of the party that wants to be the applicant before you file the application. If you file the application and assign later, it won't work. It'll be considered an invalid registration and incapable of being fixed. So if you haven't got use yet, it's much easier to move things around. So I'm just going to pause quickly to have a look at what questions have come in. I can see one, but no, I can see one, but it seems to have not showing up on my screen, so I'll try a different way. Okay, so so the question has come in from somebody who works at a university technology transfer office, where most of the licenses are patents, and once in a while they'll have a trademark license along with some registered marks, and most of the concern is here that's been raised is that where you have a patent license, it requires lots of further developmental work by the licensee, which means that the licensor, the university, can't really exercise quality control over the licensee. So it's that situation sounds like the mark might not yet be in use in the market. So that would be a situation where you'd probably, if somebody was attacking you for non-use, you'd be asking for discretion to be exercised, because if you haven't got a product that's final and in the market, then you'd be arguing discretion should be exercised because your preparatory steps, and that you're showing preparatory steps to market, and that normally would be enough. If it's a situation where they're using it, but they are maybe changing the product, and so the mark might have gone out, let's say, sorry, the product might have hit the market in version 1 and you've got the mark on it, and then version 2 is going to be updated later. I still think that's use. One of the things that you could do is when the licensee provides periodic updates to you about the work that it's conducting, and they're reporting back, even if it's under the patent space, about the product and how it's being developed, and they're reporting back to the licensor, that is the licensor investigating and checking and controlling, at least to some extent, what's being developed. And if the intention is for the mark to ultimately be applied to that product, then there's an argument that you're exercising quality control over the goods that the mark is being applied to. And in the Trademarks Act, exercising quality control is a basis for establishing authorised use. I hope I've answered that question. That's a little bit of a long answer, but just wait another minute or two to see if there is any further questions. No, it doesn't seem to be. Anything further. So I'd just like to thank you all for persevering today with our webinar. We will have some future webinars if we are not able to have our normal breakfast forum and lunch forums at the Griffith Hack office, and this is one of our first ones, so it's probably been a little bit bumpy, but we appreciate you staying with us, and I'm sure we'll get better at doing them later on. So thank you everybody for joining.